Last week, we dropped a video about the Tupac trial, and we've got so much more goods now. Yes, the jailhouse defendant did another interview without his attorney. We'll go over that. We'll also go over a sit down that the defendant's attorney had with a news station just a couple days ago, and a few other things that we were able to dig up. We're going to keep you informed on this trial as it goes along, so stay tuned. So we'll get started with Michael Sam. He announced that he had taken the case on a pro bono basis. Pro bono, meaning he ain't getting paid to take this case.
$3.99.
He claims that he's taken the case because he really believes that his client is innocent. He said he's always been a Tupac fan, really admires his music, admires him as an artist, and he had never heard of Keefe D before he got a phone call to ask if he potentially wanted to take this case. Although he's always been a criminal defense attorney, his firm does mostly personal injury cases nowadays. And he said, well, he and 3 other people on his team, a team of 4 representing Keefe, I think that's 3 staff and 1 attorney, while they're focused on the Keefe D trial, the rest of the firm is holding down the fort. And so during this short course of time that he's known Keefe D, he's gotten to know his family pretty well. I mean, well enough to even go to Keefe D's father's funeral even. He's met a lot of Keefe D's family members. And he said when he took the case on, there was about 2,000 pages of discovery. Going into trial, he said there's over 14,000 pages of discovery. That's a lot of reading. He said that the prosecution is now estimating that their case in chief will last about 4 weeks. So we've got jury selection. That's going on this week, and it'll probably last throughout the week. Might even still be going on next week. Then we've got 4 weeks of the prosecution's case, and then however long the defense needs for their case in chief. And then the prosecution would get another chance for some sort of rebuttal or something like that if anything new came out during the defendant's case in chief. So what we're really looking at here is probably about a 6 or 7 week trial. According to Michael Sam, he visited the city of Compton, kind of got to know the area a little bit, talked to folks around there. He said there's about 52 or 53 sets of either Crips or Bloods in that Compton area. Just in case you're not familiar with how small Compton is, it's a small suburb of East LA. It's about 10 miles by 10 miles. So this little tiny area with 52 to 53 sets of Bloods or Crips. Now the sets are typically defined geographically. There are certain neighborhoods where it's this set, not that set, and then you cross the street and then it's another set. And they say that the way the rule of unwritten law goes down in Compton is that if you live in that neighborhood that's controlled by the set, you're really associated with that set. Living there, you're associated. You're considered connected to whatever set rules your street. Sam admitted during this interview that a lot of people out there are trying to capitalize and make some money off of Tupac's demise. And he said, unfortunately, his client's one of them. He said it includes his own client because his own client wrote a book about it. We also learned that the defense has asked for the jury to be sequestered. Don't have absolute confirmation on this, but I believe they're going to be sequestered. And what that really means is that the jury is going to be shielded from all media, shielded from all influence, shielded so that people can't get to them and influence the outcome of the case. And so what does this mean in real life? It means hanging out in some hotel. It means no cell phones, no iPads, no TV, no YouTube, no internet connections, no computers. The defense says they want to make sure that the jury is not influenced by the media or any outside sources. Sam wouldn't really talk much about the book, but he did say that the book is the centerpiece for the prosecution. He gave indications that they're still trying to keep the book out of evidence, at least significant portions of the book. And this is a quote. No, wait, that's not Tupac. Telemarketer. So this is a quote. Whether this book is something that should be the gospel truth, that's the question of the day. Is it something where we can say, you wrote it in the book, so therefore that is what it is? That's something for the jury to decide. End quote. And so what does this quote tell us? It tells us that the defense is going to claim that Keefe D was just saying all this stuff in a book, that it was a lie, and he did it just to make some money. Ching! From the book. Sam would not say whether or not Keefe D is expected to testify at trial. He says he can't force his clients to testify or not to testify. That choice is up to them. But he said at some point in time, obviously, a decision will have to be made. We don't know at this point whether or not Keefe D is going to testify at trial. So I actually watched some of the proceedings on the very first day of trial. And during the housekeeping discussions, that's kind of a attorney vernacular. A lot of times you'll go to court for a trial or something, but there's a few things the judge wants to talk about before the trial actually starts. We call that housekeeping for the most part. And one of the things that Sam asked during the housekeeping portion was that he have the 19th off. In other words, he doesn't want to have to be in trial on August 19th. And he says the reason why he can't be in trial on August 19th is so that he can depose the district attorney of Clark County, Nevada, where this case is being prosecuted, Steve Wolfson, on an unrelated matter in another case. He needs to take a break from this case where the DA's office is prosecuting his client in order to be able to depose the DA's head in another case on August 19th. We don't know what that's about, but if we find out, we'll let you know. And to depose someone just literally means, what's a deposition? It means that they're calling someone to come to some office and sit down and be interviewed, more like interrogated, with a court reporter in the room, typing down everything that was said on a stenograph. You're giving all of these statements, answering all the questions under oath. Okay, we got some updates on Suge Knight too. He's spoken recently, and when Suge Knight talks, sometimes people listen. He says that he has no plans to cooperate with the authorities in any way. And this probably isn't surprising. In the gangster world, there's codes and credos. They don't like to talk to authorities. They take care of matters themselves. And he's at least projecting that that's where he still is in heart, mind, and spirit. He says, whoever calls me to court to testify, I'm going to hurt that party. Don't really understand what that means, but what he's suggesting here is that if the defense calls me to the trial, then I'm going to say things that are going to hurt the defense. And if the prosecution calls me to trial, then I'm going to say things that hurt the prosecution's case. Here's a quote from him. This trial has nothing to do with me, and if someone brings me there, it's going to hurt whoever brings me there. I promise you that. He said this in an interview with ABC News. So just for a little bit of background here, in February of 1995, Diddy and the notorious Biggie released the single, Who Shot Ya?
Who shot ya?
If y'all know a little bit about Tupac history, you know what I'm talking about here. Where he went to the studio and he got shot up and survived. And Tupac took that as a direct mockery of the Quad Studios event. Shakur responded by dissing Biggie on his 1996 hit, Hit 'Em Up.
Grab your blocks when you see Tupac. Call the cops when you see Tupac.
Suge Knight, he took a verbal shot on Diddy's turf during the 1995 Source Awards in New York City. The tension at the award show has been cited by many people in the hip-hop world as an inflection point in the feud between the East Coast and the West Coast rappers. So Suge Knight gets up there. Any artists out there that want to be an artist and want to stay a star and don't want to have to worry about the executive producer trying to be in all of the videos, all on the records, dancing, come to death row. He's talking about Diddy. In the early days, Diddy wanted to be in every single video of every one of his artists. So with all of this tension, Suge Knight still maintains that if Biggie and Tupac hadn't been murdered, if Biggie would have lived a couple more years, Tupac would have lived a couple more years, he would have signed Biggie to Death Row Records. He would have restored the relationship between Biggie and Tupac, and they would have been friends again. But a lot of people out there say, that turf got scorched. And a lot of people are saying they were always going to be as done as Kendrick and Drake.
Trying to strike a chord and it's probably A minor.
But what do you think? Do you think Biggie and Tupac would have collabed on something if both of them had survived? Drop it in the comments. Drop it like it's hot.
Drop it like it's hot. Drop it like it's hot.
So let's talk about the judge. We observed the first day of trial, a large portion of it. The judge explained to the defendant, Keefe, quote, "In this case, there are two enhancements. There's both the gang enhancement as well as the deadly weapon enhancement." And then she goes on to vet Keefe D to make sure that he understands a stipulation that's being filed with the court. That means an agreement being filed with the court. And the agreement is between the defense, him and his attorney, Keefe D and his attorney, and the prosecution, the state, the prosecutors. They've come to an agreement that the sentencing phase of this trial will not be handled by the jury. It instead will be handled by the judge. And the judge went on to say that if there is first degree murder, that could be 20 to 50 years. That could be 20 years to life. And it'd be up to the judge. Keefe D confirmed that he was okay with that. So if it goes to the sentencing phase, it will be the judge doing the sentencing and not the jury. A little more about the judge. In the 10-year period before this judge took the bench, she worked for the Clark County Public Defender's Office, including for 5 years on the sexual assault team. That's heavy stuff. She did her undergraduate degree in Champaign, Illinois. That's like a 2-hour drive from Chicago, just due south. She went to law school in Chicago, Kent College of Law. So you know in her lifetime, she has witnessed a lot of media attention and stories and all kinds of stuff about gangs because Chicago is the gang capital of the United States. It's widely reported by law enforcement and the Chicago Crime Commission that Chicago has more gang members than any other city in the United States, with estimates historically exceeding 100 to 150,000 gang members. Remember the gang enhancement? Well, this judge knows a little bit about gangs. Okay, so I'm struggling here. I'm struggling. Keefe D is just talking to reporters. Even, a couple days before he's going on trial, he's talking to reporters outside the presence of his attorney. Is there a candid camera in here? So this reporter asked Keefe about the memoir, the book. And Keefe said, "I didn't write that book."
I didn't write that book.
He said that he just told the author about 10 things in his life and maybe gave him like 10 photographs. And that's all he knew about the book. Somebody else wrote it. He said that his attorney, Wayne Higgins, we can't ask Wayne Higgins because Wayne Higgins is dead, was working with the author. I don't know why this matters, but Keefe D did mention that his attorney died while he was watering his lawn. He says that the author did his own research, that I never read it or nothing. And Keefe D even says that I wasn't even in Las Vegas when all that happened. The prosecutors cannot prove that I was in Las Vegas at the time that Tupac was shot. So what do we get out of this? There's some hints right here. The hints that we get out of this is the defense is going to try to discredit the book to raise doubt over the veracity, the truth of the statements contained in that book. It also seems that he's contradicting what he said to a lady on a jailhouse call a few days ago. The caller says, "What's this book they say you wrote?" He responded, yeah, I did that.
And then what's this book they say you wrote?
Yeah, I did.
He's telling someone he wrote the book, and then about 2 days later, he's telling someone else he didn't write the book. Keefe, why are you talking to reporters?
It's so dumb.
Keefe said that his family, particularly his son, is getting a lot of threats. Sympathy card? If he's convicted of killing Tupac, think about this. If he's convicted of killing Tupac, you think the threats are bad now? When he goes to prison, let me ask you this. How long will he survive in prison if he's convicted of killing Tupac, the legend? He's not going to be going to prison on the East Coast. He's not going to prison in New York. He would be going to prison on the West Coast.
Don't let the West Side ride the night.
Las Vegas isn't on the coast. But a lot of people even characterize Las Vegas as being the far east side of LA. Keefe is within 2 years of age of Suge Knight, and he mentioned something about playing football with Suge Knight when they were younger. So this goes way back. Keefe D claims that he didn't have any issues with Suge Knight. They were football buddies. He didn't have any issues with Death Row Records. He says only a couple weeks before the shooting, Suge Knight, Snoop, Tupac, they all rolled up in Rolls Royces to a club where Keefe D was hanging out, and that all four of them left together from that club to go to another club because they were all just friends, you know? But see, under the gang credo, gang rules, gang code, everybody's just friends when it's time to talk to the cops or the prosecutors because they handle that on their own.
We was homeboys once, Pig. Once we homeboys, we always homeboys.
But what is the hint we take out of this? He's trying to say that he was good with Suge Knight, he didn't have any issues with Tupac. He hung out with Tupac a couple weeks before the murder. He's trying to show that he didn't have the motive to do this. He was asked about a photograph inside of the memoir that said, "Me and my sister at the fight," and it shows a photograph of him and his sister. And it's referring to the Mike Tyson fight in Las Vegas on the night of the shooting. And he went crazy when he was asked about that photo. And he kept saying things like, "I'm wearing an overcoat in that photo. I would never be wearing an overcoat if that was taken in Las Vegas. That wasn't taken in Las Vegas. That was taken on New Year's Eve, 1997. That wasn't taken in Las Vegas because I'm wearing an overcoat. Why would I wear an overcoat and a hat over the top of a suit when it's 115 degrees in early September in Las Vegas? That's not me. That's not the night of the fight. That is me. But I'm not, why would I dress for the fight like that? Because if it was in Las Vegas, it would have been hot in Las Vegas and I wouldn't have wore an overcoat or a hat."
Why would I wear an overcoat and a hat?
You have to watch the interview yourself. He says that so many times, as if that's enough to exonerate him. Ooh, they got the wrong photograph. I'm off. He even brought it up when he was being asked about something else. "What's your name?" "You know, that overcoat, I wouldn't wear an overcoat when it's 115 degrees. That's crazy." So let's make it clear. According to Keefe, he don't wear no winter clothes when it's 115 degrees. And maybe the photo isn't from the night of the fight, and maybe it is. But who really cares? What does that photo have to do with whether or not he ordered the hit or was involved in the shooting of Tupac? Then there's a photo of Orlando Anderson, who in the memoir, I believe, is accused of actually pulling the trigger. He's dead now, though. He died a couple years after the shooting. But when the photo of Lando comes up, who is Keefe D's nephew, he goes crazy again about it not being the photo of the night of the fight. He's like, "Oh, that wasn't at the fight either. That was New Year's Eve, 1997. That was New Year's Eve. It was hot in Las Vegas, and I wouldn't have wore an overcoat." He was then questioned about a Vlad TV interview by this reporter, and immediately out of his mouth, as soon as it's like Vlad TV, is like that Vlad T, like that much was out, he was already jumping on it like, "They paid me to say that stuff." What he's literally saying is, he's saying, don't believe what I said when I thought I had immunity, but believe what I say now that I'm heading into trial within a few hours. I'm trying to avoid a life sentence here, so I'm telling the truth this time. Listen to me. Believe the guy who admits to lying. You got me?
Bet you got it twisted, you don't know who to trust.
A few minutes into the interview, Keefe threatens to end the interview. He says, "I don't want to talk about the book. I don't want to talk about the book." He pretty much shuts down the memoir. He doesn't want to talk about the book. He didn't write it. He doesn't know anything about it. He doesn't want to talk about it. Why would he wear an overcoat when it's 115 degrees? He said what he wants to talk about instead is how his family's in danger and all the lies out there. Like, that ain't me. I wouldn't wear an overcoat when it's 115. Okay, now we go to this 2008 interview. He got that one down too. He knows what to say about that one. He says, "In that interview, my lawyer said about 40 of your friends and you guys are going away. You're getting locked up. Unless," I promise you he really said this, "unless you memorize this script that I prepared for you, and when the police walk in the room, you say what I told you to say in this script." And so Keefe says that he memorized the script. Can Keefe memorize a script? He's memorizing this script, and he's memorizing it. And then when the police came in, he just said what was on the script that his lawyer had told him to say. I was lying back then to the cops because my lawyer told me to. He's dead. He told me to. I didn't do it. Keefe D says that the Clark County DA's office is, quote, Jim Crow. He said there's no black people working there. I'm not going to argue one way or the other there. I do believe there to be black people working at the district attorney's office. But he also mentions, and I'm going to quote again, the Indian man. He said that the DA's office is using this Indian man at their trial because they need to have blackface in the courtroom, and the Indian man is nothing but blackface. He said that the DA's office will make sure that he does not get a fair trial. But he also says that he survived cancer and that the Lord got his back. The Lord got his back. I think what he's trying to say here is, I'm a man of good character. He asked how he'd like to be remembered, and he said, I'd like to be remembered as a good father. Keefe mentioned somebody named Devontae Lee who's set to testify against him. But he says that Lee is lying, and Lee, why are you talking to reporters, bro? He said, Lee, he's lying and he's a bad person and he used to buy drugs from me. That'll show him. He claims that Lee is the worst person on earth and has murdered multiple people and got away with it. He said that the allegation that his son put out a hit on Lee, that's just a lie. And he can prove it's a lie because Keefe D said, I'm willing to take a lie detector test. He threw it out there. He's willing to take a lie detector test to prove his innocence. And then he also said on this lie detector test, he will also be able to prove that his nephew Orlando had nothing to do with the shooting either. And he said when he takes this polygraph test, he's going to name the real killer. He says it's Reggie Wright Jr., not to be confused with Reggie White. But you see, polygraph tests are unreliable. They're not generally accepted in court proceedings at all. There's exceptions to every rule. And to use an expert to gauge who is telling the truth and who is not would be usurping that function from the jury. In our system of justice, we believe that the jury should be the ones to determine credibility, not some expert with a polygraph that really doesn't measure truth or untruth. It just measures how anxious someone is getting, their breathing rates and their blood pressure spikes and things like that. You can fail, be an innocent person that's really nervous to take a polygraph test and fail it, or you can be a very guilty person that's just cool as the other side of the pillow and pass it. So they're not reliable. Keefe D was asked if he plans to testify at trial, and he didn't give us an answer either. He said, I will if I need to. Did I mention that Keefe, you probably shouldn't be talking to reporters? I mean, after seeing Keefe talk to reporters and write alleged lies in a book and tell alleged lies to cops and all this crazy stuff, you can see why a defense attorney would be very nervous for Keefe D to take the stand. I don't think an attorney would be able to control him, and I think he would go off on a million tangents. I think he would definitely get convicted, even if he's innocent, if he took the stand. Oh wait, we've got a reverse card alert. So here's the reverse card alert. Generally, when you're the prosecutor, you want to believe that the defendant has a problem with telling the truth, that he lies, right? The defense wants the jury to believe that the defendant is a credible witness and he does tell the truth. He's a truth teller. In this case, though, here's what's weird about it. Here's what's reversed about it, is it seems that the defense wants to argue that Keefe D was just running around telling all kinds of lies, and you got to believe us, he's a liar. He is a liar. And the prosecution wants to go around and say, hey, when this guy was running around all those years, he was telling the truth. That's not how it usually goes down, folks. It's usually the other way around. See, but the defense is going to say he was just trying to build up his street cred. He was just trying to make some money. And he would say anything or have anyone say it for him to get money back to the household so he could be a good dad. I know that the defense is still trying to keep the police interviews out of court. There's a 2008 one for sure. I think there might even be a 2009 follow-up interview. And they're trying to keep those out of court for obvious reasons. But if they do wind up coming into trial, what they're going to argue is, well, when he was talking to them back then, he wasn't telling the truth. Now, in terms of his attorneys arguing for months now and months and months. We need to keep the memoir out. We need to keep the 2008 interview out. These new interviews he's doing, while already knowing that interviews he's done in the past could come into evidence, I don't know how he's going to keep those out. Why are you talking to reporters, Keefe? All right, we talked a little bit about Mopreen, and I can't go through all of his nicknames because we don't have enough time today. We've learned also that in May of this year, he filed a wrongful death case, a civil wrongful death case. The suit cites a recent TV documentary series titled Sean Combs, The Reckoning, in which Davis says in an interview with police that Combs offered Keefe $1 million to kill Tupac.
$1 million.
Mopreen maintains that what they're really looking for is just the truth so they can get some closure. Let's talk about the jury in the Tupac murder trial. Number one, they must be unanimous. All of them must agree to convict in order for there to be a conviction. Meaning if there's just one holdout, the defense wins. I mean, it would be a hung jury and he might be able to be retried again, but he wins for now. He sees another day. And he likely gets let out of court pending the second trial. This jury pool on the first day was 75 potential jurors that came to the courtroom. And the judge explained that the first part of the voir dire process, that's the jury selection process, which is an absolute misnomer because you don't select a jury. You actually unpick a few people. I'll get to that in just a second. 75 people came up to the courtroom. Not everyone's going to be able to sit for a 6 or 7 week trial. Did I just say 6, 7?
6, 7!
A lot of people are going to have to be excused for hardship. And with jury pools, a lot of people get excused for hardship for reasons you might not think of. For example, let's say I was a heart surgeon and I had 12 heart surgeries scheduled over the next 4 weeks. And the judge says, will serving on this jury present a hardship to anyone out there? By show of hands, how many people would... And I raised my hand, they say, sir, and I'd say, that's doctor to you, judge.
You a doctor?
That's right.
I am a surgeon. If I have to serve on this jury, there are a dozen people that could die because they are scheduled for heart surgery. And the judge is going to say, Mr. Surgeon Guy, I mean, Dr. Surgeon Guy, you're out of here. Thank you for your time and service. So what I mean by deselection, you've got two different kind of challenges. In other words, two different reasons that you can strike a juror off the jury panel. One of those reasons is the hardship. If they can't serve for that 6 weeks because it would truly become a hardship to do so, then those people can be excused. After all of the hardship people have been taken off of the jury panel, then the next thing that happens is striking for cause or peremptory challenges. Striking for cause would be, an example would be someone who can't be fair and impartial. For example, in this case, if someone said, hey, I'm Tupac's cousin, that person's probably going to be stricken for cause from the jury because they have too much of an emotional tie to the victim in the case. Peremptory challenges are different. You don't really have to give a reason for a peremptory challenge. It's just a bunch of attorneys whispering over at one table going, who do you think? Who do you think? Who do you think? Who do you think? All right, let's get rid of number 6. Why number 6? Because number 6 looked at me funny. And you don't really have to have much of a reason. And so each side is going to get 10 peremptory challenges total. But here's how it breaks down. They each get 8 peremptory challenges for the people who will be seated in seats 1 through 12. That's the 12 jurors that'll decide the case, seats 1 through 12. They get 2 more challenges for seating 13, 14, 15, and 16. That's 4 seats. Those 4 seats are for alternate jurors. Those are people who are going to watch the trial, but may not go back to the jury deliberation room at the end of the trial because they weren't needed after all. But what an alternate juror really is let's say there was someone in those 12 seats as a juror that got in a bad car accident on the way to court one day.
Some lawyers learn personal injury in law school.
We learned it in hospital beds, and that's why we fight differently. We get it.
Get the personal attention you deserve. LBC Law Group puts you first.
And they're not going to make the rest of the trial then that next person, seat 13, would become the substitute or new or alternate juror. During the time where they're allowed to use their peremptory challenges, that will be the attorney-led section of the voir dire process. What the attorney-led session of the voir dire process, what that means is the attorneys themselves will be able to ask the prospective jurors certain questions like, do you listen to rap music? And things like that in order to see who they want to use their peremptory challenges on. And the attorneys on both sides are going to have to be really careful for the stealth juror. The stealth juror are people who will say anything to get on the jury, anything to say to get on the jury. I'm just going to answer in the way that I think you want to hear so that you'll keep me on the jury. Stealth jurors have an ulterior motive. The reason why they want to be on the jury so badly is because they want to write a book about it, or they want to have a cool story to tell at cocktail parties. They want to be someone that's important in their neighborhood. Whatever reason, they're doing it for their own benefit only, not to serve a function as a member of society, but instead to get paid. After the first day of trial was over yesterday, there was about 15 or 20 from that panel of 75 who were already stricken due to hardship reasons. So what kind of juror does the defense want? They want jurors who will buy into a false confession defense. They want jurors who will believe that someone might have lied in the past just for the purpose of making a quick buck, but they're able to tell the truth now. What the state does not want, they don't want quiet jurors. The quiet jurors, you never know what they're thinking. I mean, it's a coin flip. Are they going to come back with a guilty verdict or not guilty verdict? Quiet jurors are the dangerous ones. And what the state really wants is people who are just afraid of gangs. People who believe that gangs have destroyed their neighborhood. People who have horror stories about Crips or Bloods or something like that. If jurors are terrified of gangs running the street, not just pigeon gangs, I mean, we're talking like real gangs, then that's who prosecution wants on the jury. But this has really turned into a whodunit. I mean, did Keefe D do it? Or was Keefe D just so dumb that he would write a book about doing it, talk to police and tell them he did it, do interviews with police right before trial? Is he just so dumb that he's hanging himself?
So dumb, it's brilliant.
No! It's just dumb!
Or maybe he was involved. Maybe he was paid by somebody, because we know Keefe likes money, and we know that he'll do lots of things for money. He'll lie, but will he kill for money? You see, the gangs of the 1990s weren't just a bunch of bums. They became very sophisticated mafia syndicates. They had codes, they had credos, they had enforcers, they had a shadow government. They became the police in their neighborhoods. The people in the neighborhoods they policed knew better than to talk to police that actually had badges. There was a ton of money at stake in the rap business, the rap game back in the mid-90s. So here's what a lot of people think. A lot of people think that Diddy's behind it all. That Diddy is actually the one that paid the Bloods gang that Keefe D was the head of. Diddy paid money to Keefe D's gang. Keefe D, being in charge of that gang, ordered the hit. So there's stuff floating around out there that said that Diddy allegedly put up a $1 million bounty on Suge Knight and a $1 million bounty on Tupac. Some say that the white Cadillac that was used in the drive-by shooting, Diddy's behind that white Cadillac. I don't know if he paid for the rental or what, but a lot of people have said that. Even though Keefe D might be one of the dumbest defendants ever, that doesn't mean he killed Tupac. On the other hand, if Diddy needed to hire someone who was stupid enough to do it, Keefe D was the perfect mark. Now listen, I don't know Keefe D. He might be one of the nicest, sweetest, most loving fathers in the universe. But I do know this. That book, the memoir, dumb. The police interviews, dumb. The interviews right before trial, dumb. Talking to Vlad TV about it, dumb. Did I say dumb? If you want the rest of the information about the Tupac drama, check out that video. We just dropped it a few days ago. Nothing I say in any of the videos on this channel constitutes legal advice. If you want legal advice, come to my law office and sign some papers and we'll go from there.